Let's continue exploring Roman law by looking at a question that's a lively debate among contemporary historians, legal historians, and political philosophers. This is the question, what are rights, and where do rights come from? We'll be looking at this question across many of our lessons, but we want to ask specifically, in the context of Roman law, are there rights in Roman law? And more particularly, what do we mean by that? Are there human rights? Are there natural rights? And so we'll take our conversations a step further by trying to define those and then looking at Roman law and asking if they exist within the legal system of the Roman Empire. Roman law, after all, says that justice is the will to give each person what they are due, to give each person their use, to give each person their right. And if Roman law sees justice as an attempt to give each person what they are due, then we must say, what does it mean by this concept of right? Is it similar to our concept of human rights or natural rights? We've talked about rights going back to some of our first lessons, looking at Hofeld's system of what a rights claim means. And we've seen that rights can have different kinds of aspects. They can be claims, they can be privileges, they can be powers, they can be immunities. And it's important to keep that conversation in mind as we think about this problem. Now let's think about the nature of rights from another direction. Let's think about not what kinds of powers or claims rights have or make, but instead, where do rights come from? How are they specified? And let's think in terms of three different kinds of origins for rights. One is simply what we can call a legal right, some kind of just claim that can be enforced by law. And so a legal right is specifically a right that's enforceable by law, a kind of claim that an individual can make that can be enforced by the state because it's just. Legal right. Then let's think of civil rights. Civil rights. Now, when an American says civil rights, we think particularly about the kinds of rights to participate in political life that are guaranteed in our constitutional system. And we think more particularly about the kinds of political rights in our own history that were denied to certain categories of even citizens, especially the legacy of race and the civil rights movement that guaranteed political rights, that guaranteed the rights of participation to African Americans, rights that were protected and guaranteed, like voting. And so civil rights, more generally, are rights that flow from citizenship. And so a legal right is specifically a right that's enforceable by law, generically. Civil rights, we mean the rights of the citizen that flow simply from the fact of his or her citizenship. And so when we say civil rights, we're talking about an origin. We're talking about the place that those rights flow from and why they are justified. They're the rights of the citizen. A third category, though, are what we can think of as human rights. These are sometimes called natural rights, sometimes more blandly individual rights, and those may have different connotations, but let's think of them as human rights. Legal rights are rights that are specified at law. Civil rights are rights that flow from citizenship. Human rights are this special category of rights that flow simply from the virtue of one's humanity. Human rights have a very particular and a very powerful charge in our own political discourse. To say that something is a human right implies that it's fundamental, that it's something someone has simply by virtue of being human. Do these different kinds of rights exist in Roman law? There's been extensive debate among scholars whether it's correct to say that there's even a concept of legal rights in the Roman system of law, because legal rights are kind of subjective claims that are vested in the individual. But there's really no doubting that Roman law protects individual legal rights. The Roman law of property is fundamentally a system for providing the enforcement of an individual's just claims to have certain kinds of privileges over things. And so there's no doubting that Roman law can be considered a system of legal rights, a highly specified and complex system of legal rights. Are there civil rights in Roman law? This is an interesting question, and the answer is fundamentally, again, yes. There are certain kinds of claims that individuals can justly make that are enforceable in Roman law and that flow from their citizenship. We'll look in the next lessons at some examples that are well known from the history of early Christianity. And in fact, one of the most important features of the history of the Roman Empire is the gradual extension of citizenship across the Roman world. When Rome conquered the Mediterranean, citizenship was still the privilege of Romans and eventually inhabitants of Italy. But over the course of the centuries, the Romans ruled this Mediterranean world, and they began to assimilate its inhabitants. It's one of the hallmarks of Roman imperialism, that the peoples that it rules gradually become Romanized. And so the French, to this day, think of themselves as deeply influenced by Roman civilization, even though they're not conquered and brought into the Roman Empire until the age of Julius Caesar. But this is the nature of the Roman Empire, is gradual Romanization. And it happens at different paces in different parts of the empire. In some places there is severe and violent resistance against Romanization, but inexorably, Roman citizenship and the Roman way of life spreads all across the Mediterranean world. The Roman citizenship is especially prized because it brings with it certain specific kinds of privileges, certain civil rights. And the rights of the Roman citizen gradually spread throughout the Mediterranean world until a monumental legal act in 212, passed under an emperor named Caracalla, decreed that all free inhabitants of the Roman Empire were to be made citizens. And so we can think of this as a highly symbolic date, 212, when Roman citizenship becomes effectively universal around the Roman world. This was also one of the greatest generations of Roman law. And that's no accident. This is the generation that produced the greatest of all the Roman lawyers, a man named Ulpian. Ulpian, the greatest of the Roman jurists. He himself is from the East Mediterranean, from Tyre. He rises throughout the Roman imperial system, the Roman administration, and becomes a very high-ranking officer of Roman state. He is the most important of the Roman jurists. And the Digest of Roman Law, the most important text of Roman law that was compiled in the reign of Justinian, is 40% comprised of the writings of Ulpian. So he's fundamental to the period of classical Roman law. He's a provincial. He's from the Eastern Mediterranean, but rises to the heights of Roman administration because of his talent. And he is a particular expression of this moment of Roman history, when a provincial could rise to the very heights of power. And he represents this generation when citizenship became universal across the Roman world. And to a large extent, Ulpian's legal writing is part of the context of Romanization around the Mediterranean. And it's been asked, does Ulpian's legal thought allow for a concept of human rights? Ulpian's thought seems to be influenced by Stoicism, a Greek philosophy that became the ordinary philosophy of many Romans across the Roman Empire, that taught that there was an orderly cosmos, a natural order of things that was discoverable by human reason, and that taught that all individuals had a kind of moral worth, that all humans were naturally equal in moral terms. And so there may have been some influence of Stoicism in Ulpian's outlook. He's certainly influenced by the universalization of citizenship in his age. And he has great faith in the ability of jurists and in the ability of law. Ulpian writes that law is the art of the good and the fair. And he believes that the jurists are priests of the temple of the law. So he has a very high ambition for the potential of law to embody that which is just. And it's therefore been asked, does Ulpian envision a kind of right, a kind of claim that one can have simply by virtue of their being human? And so I've asked you to look at a number of passages that are from the pen of Ulpian and to ask, is there a sense in any of these texts that there is a human right?